My lord, petitioner claiming
We filed a reply. Uh, the reply has been filed. The petitioner was, in fact, Your Lordship, she was an Anganwadi worker. Initially, they were not granted extended the benefit of the scheme. Subsequently, by order dated 11th of October 21, which is a central government notification, the benefit of the scheme was extended to them. Now, that provided that they should have been working as frontline health workers who may have to be in direct contact and care of COVID-19 patients and who may be at risk of being impacted by this. Now, the death occurred on 22nd of April 21, and the deceased was she was on strike from 26th of March 21 to 30th of April 21. This is during this time she contracted COVID, and sure R1 is the relevant document that we have.
only they have said, my lord, all the workers out of any strike now. उस समय तो ऐसा था नहीं.
Actually, I'm paying for 2 weeks time to file reply in this case, sir, for Union of India. I'm appearing for the respondents.
Please, my lord. My lord, I am petitioner in person in this matter.
They not complied with it.
We have complied and filed the compliance report for about 2 weeks time and filed the compliance report. We have carried out all the directions covered. We have inspected the.
Have you filed it? Well, may serve a copy on the party.
So the copy and then I will have it. I will take 2 weeks time. Affidavit has to come from outside.
They want time to file the reply.
No issues, my lord. I am waiting for the reply, my lord. I will not object to the same, my lord.
Yes. The respondent counsel seeks time to file his reply. At request, call on. 9 January is all right?
Please, my lord.
9 January.
This case I filed my Bagalatnama. I have instruction, my lord, within a week, 4 weeks time, I'll comply with the order.
Lordship, the pleadings are complete in the matter, but 3 documents are missing from the rejoinder, Your Lordship. I am praying for just 1 day to file those documents, Your Lordship. Sir, what has happened that this case has been mistakenly dealing with bunch of 150 criminal cases, Your Lordship, criminal appeal. That's why the case was not listed since long, Your Lordship. That's why I filed that IA to dealing the matter. That same has already been dealing, Your Lordship. But the case is that I have challenged the notification, Your Lordship, for departmental examination, Your Lordship. Departmental examination for promotion, Your Lordship. That same is at page number 11, annexure P1 of the petition, Your Lordship, whereby 2 arbitrary clauses are added in the notification. The same has been challenged by this petition, Your Lordship. The one is that the employee in a grade or category with initial basic of equal or more than rupees 2,960.30 per month or rupees 1133.08 per day shall not be considered eligible as per NCWA 10. And another is, your lordship, fourth, employees working in critical designation, say paramedical staff, HEMM operator and electrical supervisor, for which the NCL has resorted to avail the services of ex-employee as per CIL guidelines for availing the services of superannuated non-executive cadre employee who worked in a statutory essential critical nature of job shall not be considered eligible to apply. The basic ground is, your lordship, all these promotionals are done as per the cadre scheme formulated by Coal India Limited. The cadre scheme has not been followed. There is no such criteria in the cadre scheme regarding the initial basic of the employees, your lordship. My contention here in, your lordship, I have filed the relevant part of cadre scheme, but certain pages of that cadre scheme are missing from this bunch, your lordship. That's why I am praying for just 2 days or 1 day's time so that I can file those documents, your lordship. Sir, what has happened? The petitioner herein is a HEMM operator. The qualification to join as a HEMM operator is matriculation and heavy license. All the workers who are employed in coal mines, either they are electrician, either they are fitter, welder, all the employees are eligible and they can appear in the departmental examination, qualify the examination and become a junior chemist trainee grade 2 or junior technical inspector trainee grade D. But the HEMM operators are prohibited from the same by clause 4, your lordship, citing the reason that they are working as the HEMM operators has been mentioned in the first line, your lordship. They said that this is critical designation, therefore heavy earth moving machines, your lordship. It's dumper, dozers, drag lines, they all are drivers, your lordship. Because, your lordship, what has happened, the department has given the departmental vacancy and stated that any person who has graduation in science with chemistry, as per the cadre scheme, your lordship, any person who has having graduation in science with chemistry and is a permanent workman or employee of the company with 1 year service is eligible to appear in the examination and get promoted for the same. Now, electrician, fitter,
My lord, I say, my lord, these dumper operators, they are appointed on a particular post. They have got a cadre scheme for their promotion. The junior becomes, my lord, these were, my lord, we fixed it below the pay scale, that is science. Yes, my lord. So that we have restricted for 2 people not to come. Those who are having the pay scale 1133, more than that. The dumper operators are having more than that. Agree. So general Mazdoors are having only 1133 pay scale. So we are in recruiting them. Now heavy earth moving machines operators, we have a shortage of these persons. We give them training, we recruit them, and we are taking the retired employees. Therefore, we are restricting them to appear in these examinations. We made it, my lord. HEMM operators. 2 things we made it, my lord. They get more than this 1133. They get 1154 initial. More than that, my lord. Only general Mazdoor gets 1133 in our organization. Let's start with the general Mazdoor. Then, my lord, what it happens, my lord? We recruit by the direct recruitment all posts except the land hosties and the compassionate appointment. Those we
So what has happened, your lordship? In clause 3, they have stated the word initial basic. Initial basic is something which employee gets after promotion. But when we come to joining basic of general Mazdoor and HEM operator, the joining basic of both general Mazdoor and HEM operator is same. What has happened, after working for 3 years, they joined in category E, they joined in category 1, subsequently they got promoted to next category, then next category, and they are referring to my present initial basic. But the day when I joined the company, the general Mazdoor has also the same qualification, except the same is at my rejoinder, your lordship. Page number 16, your lordship. The first, thus so 1011.27, your lordship. What has happened? I am, sir, category first. Existing pay category first. As per the revised pay scale of 1/7/2016, it is 1011.27, your lordship. And what they are referring is excavation. Yes, the initial pay is never the criteria. Since last 40 years, initial pay was never the criteria. The cadre scheme formulated by JBCCI never talks about any kind of initial basic. The only requirement of the cadre scheme is that that person must have the graduation with chemistry and has having working experience. This is arbitrary, your lordship. CIL has 8 subsidiaries. All the other subsidiaries are following this criteria, and no one has imposed this condition of clause 3 and clause 4. And even for the namesake, if their criteria is believed to be true,
It's completed.
lordship,
In fact, my lord, identical case.
they have, your lordship, they have not complied their own clause 3. As per page 14 of my rejoinder, your lordship, at serial number 19, Prem Sagar Vaishya has been selected, your lordship, and he is not qualifying the third clause, your lordship. He is having the same basic which they have mentioned.
An identical case was also came up for the division too. The division bench was dismissed. Only difference is that there was post of clerk, but the conditions were.
Your lordship, that is for non-technical, technical to non-technical, and this is from technical to technical.
Reason is my para 6.2 notes.
So that issue was not raised before that court, your lordship, because that was for that was for technical to non-technical. But in this petition, the petitioner, he is a technical employee and is paying for the technical post, your lordship.
My contentions, it is there.
Lordship, there is entry model in my petition, your lordship. I may be heard for 2 minutes, your lordship. I have many submissions to make before this road. Sir, the problem is that, your lordship, if these petitions are dismissed, then sir, they will continue. What they have done, your lordship, for promoting them to be chemist or technical inspector, they are given this notification, but they are promoting dumper operator to the post of overseer. They are promoting dumper operator for the post of overman. I have filed each and every notification with my rejoinder, your lordship. I am just praying for one opportunity. Just 2 days time be given, your lordship. I will demonstrate. Just 2 days time I am praying for, your lordship.
This 3 weeks time for filing rejoinder. The husband of the prisoner was working as Thai Karmi Lordship, and during the period of service, he has died due to COVID-19 Lordship. The compensation has not been.
Why has been filed by us? Lordship, the petitioner was admitted on account of being infected by pancreatitis. Thereafter, Your Lordship, there was the cause of death is organ failure, complete organ failure, cardiac arrest. This is the opinion of the doctor, Your Lordship, at annexure R1. He died due to cardiac arrest, and the time of his admission, it was
But cause of death has not been mentioned in the death certificate, Lordship. We have applied for our right to information, Lordship. Kindly see that page number. Yes, all treatment has been provided to the petitioner. Kindly see page number 28, Lordship. The remdesivir injection was injected, Lordship. Page number 28. Doctor has not stated, Lordship, what has happened, Lordship. He was hospitalized and COVID ward, Lordship, and thereafter, Lordship, page number 35, Lordship. After death, Lordship, his funeral was with the protocol of the COVID-19, Lordship, and thereafter, Lordship, one document, another page number 37, Lordship. We have demanded document, Lordship, in which, Lordship, the civil surgeon has. My submission is this, Lordship. He was hospitalized in COVID ward, Lordship, and after death, Lordship, his funeral was with protocol of the COVID-19. The treatment was provided, COVID, the remdesivir injection was injected, Lordship. And one important document, Lordship, kindly see page number 37. Yes, Lordship. But in the sense of the test is negative, Lordship. Despite of this, Lordship, the another P12, Lordship. The issue has been decided, Lordship, in the sense of if the test is negative. In absence of negative test, Lordship, the issue has been considered by learners coordinate single judge, Lordship. Page number 50 onwards, Lordship. Annexure P12, Lordship. Page number 54, Lordship. Para 2, Lordship. In my case is the CT scan report test has not been. The report. My submission is this, Lordship. The treatment was provided. One Lordship, page number 37, Lordship. Kindly see last para, Lordship. मृत्यु प्रमाण पत्र के सॉफ्टवेयर में मृत्यु का कारण अंकित करने का ऑप्शन नहीं होने के कारण मृत्यु प्रमाण पत्र में मृत्यु का कारण उल्लेखित नहीं किया गया. Medical record, Lordship, the treatment has been provided, Lordship, and the test has not been. But if, Lordship, that CT scan test has not been done, Lordship, so this is the fault of the doctor, Lordship. I am. But my submission is only this, Lordship, in absence of that test report, Lordship, the same case. No.
Reply is awaited.
Signal 4 weeks.
Okay.
Lordship, the municipal corporation bond is the sunset. My lord, this is the case where the petitioner has agreed, but her name is not reflected in the MF, guest faculty portal. My lord, the reply is almost ready. We have made payment of the arrears of the salary to her. Within a period of 2 weeks, we will file the reply.
Lordship, I pray for 2 weeks time. What do you mean? 2 weeks time I pray. Because due to medical, I'm not able to hear. That's why I'm not filed the amended petition. I'm suffering from fever. That's why I'm not here, sir. That's why I'm praying 2 weeks time. Yes.
I'm just praying for 3 days in this matter, my lord, to comply. The instructions has to be seen, sought in respect of the fact that whether the amount for August to April, which he has worked, that has been paid or not, my lord. As my lord, there was a joining. I'm so blessed.
Obliged.
Comply. So blessed.
Right. The petitioner was seeking age relaxation, which we have subsequently granted. My laws have disposed of similar petitions.
Yes, that is.
In the recruitment of assistant professors. That circular, I am just getting a print, my lord. ये 6 10 का circular है ये. अभी दे रहा हूँ मंगवा.
Yes.
I'm just getting a print. I apologize for that. Of this circular dated 6/10. I'll supply him.
This is a case, Mala. There's
these petitioners, they were working as guest lecturers. And in the next session, they were not permitted. Now, during pendency, petitioner number 1 has been granted the appointment. There was a change in the policy. They have said that all the persons who were working previously, they will be appointed. Now, they have made a rider that the persons with PhD will only be appointed. Number 1 has been appointed. Number 2 has not been appointed.
My lords, in the reply, what we have stated is, my lords, what is their contention is that they have been replaced by the private respondents. Now, in my reply, my
The
lords,
change in the policy has come after this reply was filed. So they would be required to seek instruction with regard to that because it's subsequent to this. So
they
they
seek instructions as per the new policy. What remains the
as far as number 1 is concerned, they have appointed. But what they say in the new policy, they say that the person having PhD will be appointed. So they have appointed number 1, he is having PhD. Number 2 is having MPhil, my lords. MPhil they are not appointing so far. They may seek instruction with regard to 2 or what are there.
policy then?
Because that was under consideration that even MPhil will also be considered.
So I'll have to seek instructions about that. But
I prefer withdraw my lord this petition.
Is my lord's position. No, this was with regard to the medical waste disposal facilities. Thank you. My lords.
Or there is a case where the stay is operating against me. The interim order was vacated by my lords on the last date. They went in appeal before the Supreme Court. My project is, my lord, I've already, my lord, installed the plant.
आपके पास है?
If possible, more in the next week, my project is not. But it's been Yes. Or I may be permit. I'm filing the additional reply also.
Lordship, arguing counsel had filed the adjustment till date, Lordship. And reply is awaited, Lordship.
The Lordship, this is a case for grant of COVID compensation, but that's 4 weeks time in the
Of life.
Yes, ma'am. We'll file.
State's reply is awaited, my lord. Lord, I am the aspirant under the category fall under disabled category. I am a visually impaired aspirant, my lord, of assistant professor examination, advertisement of which was conducted for examination of 2022, my lord. My lord, challenges to the impugn order, which is at P5, my lord, at page 28. Lord, that is on behalf of PSC, my lord.
State has to.
State has to file.
Time to file my reply, my lord. So,
Assistant professor examination for political science subject.
Not on the last date, notices have been issued and you have been served, but no one has appeared. Lord, I had to continue.
In this matter, I'm just seeking 2 weeks time to file the reply. 4 weeks time to file. 4 weeks time to file the reply.
There's moved an application for amendment, the petitioner is. One word that he requires some amendment. He's not challenged the validity. In fact, he's saying that he should be granted appointment because the reservation policy is not being seeking to quash an order passed by the General Administration Department.
My lord, on the last day, since the respondent was insisting on hearing on vacating stay, lordship had indicated that your lordship may like to hear it, my lord, matter. Kindly see the second last order sheet, my lord. My lord, your lordship had stayed the subsequent bid, which they have now cancelled. So that cause goes, my lord. But they say they want to again invite a fresh bid, my lord. For that IA which came up on the last day, lordship indicated that.
I'm appearing for respondent number 1, madam. Because of the stay order, we are not able to cancel the second bid. That's why I moved an application for vacating stay, madam. And last date of hearing, my lord has observed that it has to kept for hearing.
First week, my
lord. My humble submission, the last tender, which is going to be expired on 19th December, and prior to that, it has to be had. Otherwise, it will be a great hardship for us, my lord. Because we are not extending the tender, and the last date of tender, the tender is going to expire on 19th December. My lord, whatever, kindly see for a moment. My lord, give us the first tender. because my lord, I have no option to use my discretionary power to accept or reject the tender. We have to regulate by the GM terms and condition. And because that petitioner was suspended in GEM portal.
Yes, they cancelled without reason, invited second. My lord state that now they want to cancel second, but they say there is an order that they shall not proceed. They can't even cancel. So lordship may allow them to cancel it, my lord. There is absolutely second tender they can cancel.
I have to seek instruction because kindly see the for a moment the terms and condition of the GEM. We have to go by the terms and condition of the GEM, and we have no discretionary power to accept or cancel any tender. Otherwise, it is.
My lord, this your lordship considered on the previous dates. My rates have been disclosed on the online portal, my lord. Now I there is no point in bidding any further, my lord.
In second tender, they have also participated, my lord.
And everybody matched my tender, my lord.
They have also participated in second tender.
I am on the approach and the decision taken, my lord. Risk of business, my lord, I am ready. My lord, what has happened? My lord, what has happened here is, my lord. Admittedly, my lord, I have no default so far as the tender inviting authority is concerned. No violation, nothing. Respondent number 2 is the GEM portal, my lord, which is the government portal for online transactions, my lord, of tender. That's a GEM portal, government e-marketplace. So you have to register on that portal, pay their charges, and that portal is used to invite the tenders by the government, my lord. Tender bids are submitted. Everything takes place through that portal. Now, in one of my previous tenders with some other government in March 23, 6 months ago, there were certain dues which respondent number 2 was claiming from Food Corporation of India, my earlier tender inviting authority, and I was L1 in that tender. That issue remained pending between Food Corporation, nothing to do with this tender, and the GEM portal. For 6 months, my lord, nothing happened in that tender. In that so-called charges, my lord, commission charges which GEM takes. My lord, this portal was open for this tender from 8th July to 5th August, about 27 days. Right from 8th July, previous 6 months, there was no recovery, no action against me. 8th July, when the portal opened, there was no impediment so far as I was concerned. My lord, for this good 28 days, no problem. I accessed, they provided me the online access, username and password. I submitted my tender on 5/8/20, they accepted it, my lord. The tender inviting authority. Now, GEM portal is nowhere in picture. The tender respondent number 1 accepted my bid. They technically evaluated it, my lord. Then also there was no problem. They declared me L1, then also there was no problem. After that, my lord, respondent to GEM portal somehow, my lord, says that they suspended me on account of that 6-8-month-old dues from some other government agency, some other tender. And taking a clue from that, respondent number 1 has cancelled my L1 bid. Now, admittedly, there is no violation of any term condition of the tender inviting authority, respondent number 1. Admittedly, my lord, there is absolutely nobody's case that I violated anything. There is no dispute that I was allowed to participate. No dispute, my lord, that portal remained open for 27-28 days. There was no suspension. No dispute that I was declared L1 on the website. And they cancelled my L1 thereafter, my lord, on the ground that you had some dues with respondent number 2 GEM portal, my lord. And that is the only ground. And they displayed my rates on the website, on the portal, my lord. I leave it to Lordship.
One lot, right?
Next.
My only anxiety, prior to that, it has to be.
Rather than praying 2 weeks time to file rejoinder in this matter. My lords, I'm not the counsel in this matter. My lords, I'm appearing on behalf of Shri Rajeshwar Rao, my lords, due to some personal difficulties.
My lord, he has suppressed the information in the form, my lord. He applied for the post of assistant grade 3. He did not suppress, he suppressed the information that there was a criminal trial against him, my lord. And that is directly in violation of the advertisement as well as the guidelines issue. Then subsequently when it came, they are asking that they are not giving joining despite being selected through the process of appointment.
Highly obliged. My lord, this is third round of litigation, my lord. My earlier 2 rounds, I have withdrawn the petition, my lord. My lease has been cancelled for non-payment of dead rent for the year 2019 to 2022.
My lord, pray for a short time to file my.
In this, may I make a request, my lord? My lords have already passed some order. There are various cases which are pending before my lords, my lord. डेड रेंट के मैटर्स में my lords ने पूछा था कि आप डेड रेंट पूरा जमा करने के लिए तैयार है? हमने कहा था हाँ, I am ready to pay entire amount, my lord.
My lord, he has filed similar petitions earlier and withdrawn it, and he has not disclosed that fact. So this is the third petition, my lord.
My lord, in fact,
On that ground, my lords asked me to file a response, my lord. Unfortunately, I'll file my response.
it was my mistake. Right. Obliged.
Reply is awaited, lordship. Senior counsel was this. No, lordship. Election petition, lordship. This is the election petition, lordship.
That's what they are saying is that the reservation which was done at the triple point of time in 2020. Serial number 12 also the Sabda matter.
So reply is awaited, lordship. Let next week, lordship. इसमें ग्राउंड है लॉर्डशिप जो बता देंगे सीनियर लॉर्डशिप नेक्स्ट वीक कर लें इसको डे आफ्टर टुमारो लॉर्डशिप 2000 लास्ट डे ऑफ ऑर्डर लॉर्डशिप लॉर्डशिप तो रिप्लाई के लिए काफी समय से तो रिप्लाई भी इन्होंने पेश नहीं किया लॉर्डशिप दैट्स व्हाई
Same not about last time also none has appeared. Today also another captain passed on.
Well, this is that but fact matter. In fact, I verified there are as many as 60 petitions are pending in various high courts assailing the but fact knowledge. In fact, our high court Indore bench has also obtained a petition.
Unless the Union of India should have been the party because it's a central act enacted by the parliament.
My lord, in the instant petition, challenge is to the clause of the advertisement whereby minimum qualifying marks in the interview for the selection of civil judges has been made, my lord. That is annexure P1, my lord, the advertisement. Clause 3(1), my lord. My lord, 40% marks, my lord. Interview was to be held of 50 marks, my lord, whereby 20 marks were the qualifying marks. Minimum 20.
Two judgments have
My
been
lord,
passed.
my lord, actually that judgment has not considered Bharat Bhushan, which has earlier, my lord, of this court, my lord, has held that such prescription of minimum qualifying marks is against the rules, my lord, rules of 94. That has not been considered. If my lord permits, I'll. No, my lord, rules does not provide for minimum qualifying marks. If my lord permits, I may hand over the judgments, my lord. Bharat Bhushan. My lord, the judgments which have been annexed with the reply, my lord, both the judgments does not consider this Bharat Bhushan, my lord, which has in fact earlier held that. But my lord,
I have filed that judgment on record, my lord.
That is on record, my
The
lord,
judgment is there
with
at
reply.
page number 14 of the reply. And this has been taken to Supreme Court. The SLP is pending there.
I am submitting that regard as well, my lord. As far as those judgments, my lord, one of the division bench 1 and one of division bench 2, my lord, both those judgments haven't considered the judgment of the Bharat Bhushan, which is of the bench of equal strength, my lord, and an earlier order, my lord. In such a case, my lord, Jabalpur Bus Operators Association, my lord, mandates that, my lord, the earlier judgment should be looked into, my lord.
Lordships have considered the Supreme Court judgments and then.
My lord. My lord, those Supreme. My lord, actually, this is for the subsequent. That was for the earlier selection process, my lord. This is. My lord, my lord, my submission is, my lord, this, my lord, Bharat Bhushan be considered in this as well, my lord, and then we may get in order. Because, my lord, Jabalpur Bus Operators Association says, my lord, that if there are two contradicting views, my lord, then the order of the earlier court must be looked into, my lord. And, my lord, after that, my lord, as far. My lord, as far as Supreme Court is considered, my lord, the judgments being relied upon, my lord, K. Manjushri and others, my lord, they have already been considered in Bharat Bhushan, my lord. My lord, may please see, I'll take my lords to paragraph 12 to 15, my lord. 12 to 15. My lord, the first one is Ramesh Kumar. That has been relied upon in this judgment, my lord, in the two judgments which my learned senior is talking about.
My lord, if I may make a submission, my lord. My lord, if my lords permit, my lord, either IR be given or my lord final order be passed, my lord. Most certainly, my lord, but I can pray for my lord's discretion. My lord, it may be heard finally any date, my lord. My lord, then interim be granted. Only that the seats may be kept vacant, my lord, because they have already proceeded subject to final orders. Highly obliged.
In this case, the executive engineer terminated the tender of the petitioner. The appeal thereafter should have been decided by the chief engineer, which was decided by the superintending engineer. Thereafter, NIT was also issued minutes. The lordship had stayed the NIT. I'm in 23. The state the NIT minutes. There are a number of similar cases also minutes, which have been withdrawn by the petitioner to approach the competent authority, and if your lordship permits, instead of the superintending engineer, the appeal will now be decided by the chief engineer, the competent appellate authority. My lord's permit, this matter may be disposed of. Yes, my lord, the superintending engineer, in fact, is not the appellate authority. And under some mistaken belief, he decided the appeal. The appeal ought to have been decided by the chief engineer. Yes, my lord, it's our appeal. If no, ma'am.
No, by this petition, my lord, the petitioner is not challenging any specific order, my lord, but challenging the conduct of the authorities. My lord, the petitioner is dealer of the petrol pump, my lord, and at one hand, my lord, the matter is kept pending for issuance of completion certificate. At other hand, my lord, the NHAI is furthering for the demolition of acceleration and deceleration of road of the petrol pump, my lord. My lord, in the year 2018, advertisement was issued. I am, my lord, dealer, petrol pump dealer, my lord. Retail outlet has been allotted in name of the present petitioner. BPCL awarded that my lord, license of dispensing and selling of the my lord, fuel. And thereafter, my lord, the completion certificate, the provision NOC and everything has been done. The matter has been kept pending for merely issuance of final, my lord, the completion certificate since year 2019. Thereafter, my lord, there are various recommendations on the part of the respondent authorities itself, my lord. Despite that, there is no completion certificate which has been issued by the respondent authorities. Now, meanwhile, the matter was pending. My lord, on 2nd of November, my lord, the authorities approached the pump and my lord, started demolishing the acceleration and deceleration lane of the pump, my lord. My lord, this is the approach road whereby the vehicle entered the, my lord, the petrol pump, and the exits the same. Acceleration, my lord, is the acceleration lane means the approach road by which vehicle entered the pump, and deceleration. I beg your pardon, my lord. I'm sorry, my lord, I could not understand. My respectful sound. But that has nothing to do with my issuance of completion certificate, because because my lord, they are willing to demolish that, my lord, approach road, my lord. And that is to without issuing any notice, without issuing any communication to the petitioner, my lord. All the communication has been done in the name of BPCL, my lord. Now, entry, it may be termed to be entry and exit lane, my lord. My lord, in technical terms, it is that is functioning, my lord. Completion certificate is required for the purpose of my lord, examining the fact that entry and exit lane has been done in accordance with law. That report is in favor of the petitioner, my lord. Permission was given by BPCL. That has been annexed in the petition, my lord. The permission was granted, the license has been granted by BPCL. And the NHAI has to issue the completion certificate in regard to structure of the petrol pump. My lord. I need that completion certificate, my lord. That issue is pending before the authority. That is all we want, my lord. But that I have mentioned that why because the National Highway Authority, my lord, is willing to demolish the entry and exit of that particular pump. That has already been, my lord, that has been constructed. My lord, for a moment, Annexure P14 may be seen. P14. It's a principal NOC granted by NHAI.
6 minutes.
My lord, there are policy by the government of India, my lord. And earlier the regional office was Bhopal, and thereafter regional office was changed to Jabalpur. Until then, my lord, the respondents may kindly be restrained from taking any coercive action against the petition. Because if that is demolished, my lord, that will adversely going to affect the petitioner's right, my lord. Because nothing has been issued in name of the petitioner, only communication has been done in name of BPCL. Some protection may kindly be. My lord. Much obliged.
एक कॉपी रिकॉर्ड बिल्कुल I'm sorry. Something. Well, I'll submit one more. I could get just 2 copies, not just one. I have one minute. My lord, that is page 11, my lord. Rule number 18, my lord. May I read it? It was just compiled 5 minutes back, my lord. एक गलत लग गई ये वाला page 11 my lord, rule 18 my lord. A university seeking recognition of its degrees in the law for the purposes of enrollment in the bar shall provide the inspecting committee of the Bar Council of India all necessary facilities to examine the syllabus and of the course designated. Number 2, my lord. Condition number 2 in that, my lord. Required number of teaching faculties as prescribed by the Bar Council of India and the University Grants Commission. They have adopted the University Grants Commission rules, my lord. According. Where is that? It is only in terms of condition number 2, my lord. Required number of. For that, my lord, that we have stated in page 6, my lord, of the reply that we have tried, my lord. The condition of appointment of the teachers and the number of teachers, my lord, to be appointed. Ratio between student and the teacher, my lord. In the reply, my lord, page 6, my lord. That would be paragraph number 1, 2, 3, my lord. My lord. Page 6, my lord. Third paragraph, my lord. However, the following conditions may be imposed on the Department of Law, Rani Durgavati Vishwavidyalaya, Jabalpur MP, along with BCI approval that may be granted in future. Now, this was an inspection carried out, my lord, on, my lord, and
500.
my lord, that we have directed them that this ratio is to be maintained. And the appointment of the teachers, they should have the minimum qualification of LLM coupled with NEET. NEET is National Eligibility Test as required under the UGC. That they should have this and that Lord, that is what we have said. That may be granted in future. You should have it. We have asked them to have it, my lord. This is the inspection report, my lord. We granted recognition subject to fulfilling the certain conditions. We directed them to fulfill the. Look, this information is not given by the university to the. Look, that is what we have said. Another inspection next for the next year would be done. My lord, my lord. My lord. My lord. It would be
12,
10 plus
12, 30,
12 or 13.
They have
four regular and 5 as guest faculty members. 9. That was on the day the inspection was carried out. That is on 11/5. Miller.
We can't count guest faculties, my lord. Guests are not to be counted, my lord. No.
Four regular. 5 guest faculty.
Guests can't be counted, my lord. It won't make 9.
Miller. It will be placed before the committee of the members of the Bar Council, Miller. I'll inform them. They had to hold a meeting and they are not subscribing to the standard is number 1. Subject to fulfilling, Miller. It is a university college, Miller, government college, opened in the university only. Miller. Miller. No, they have to subscribe. They have to subscribe to the standard, Miller. That is it. No. Since there were deficiencies, Miller, we required them. We directed them, Miller. Miller, this was on 11th of May, Miller. 11th May 2023. Miller, this inspection was a surprise inspection that was carried. Miller, 50 years, Miller.
Milord, it is a renewal, but as the reply shows, Milord, they have done it retrospectively for many years. Lordship rightly read, just because the fees has been deposited, they have been regularized, Milord, from previous years.
Regularized subject to the inspection that is carried out. That inspection was carried out on 11th of May 2023. And since there were deficiencies, Milord, earlier was in 2002,
2004,
5. Well, there was these, this I, the,
My lord, lawyers committee inspected in 2014.
no, no. How much is this sanction spent?
Even state is not sanctioning. My lord, they may enforce, but then university has to appoint as per the post sanctioned by the state. And as the reply says, my lord, state has not even sanctioned beyond 8. So even fault is at the end of the state also not sanctioning its own college staff, my lord. University not appointing its staff for the last 10 years, my lord.
From NES. From NES. No, NES.
Different law college.
Many, Mr. Nagaraj.
we have a good alumni, my lord. I would not say much, my lord.
Here it was in.
Miller. 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 The Bar Council of India was implemented as a party by the directions of this Honorable Court only. Miller. Miller. The standards may be low in as far as the infrastructure regarding the library and the number of teaching strength is concerned, my lord. But then there was a direction given to them to appoint, to comply with it, maintaining the ratio of 40:1 and all. Another inspection will be done to find out. We do not.
We, sir, the envelopes are about to be opened in another 7 days for P, my lord. So we'll have the sanction strength, my lord, as per the state government's approval. Within no time, we'll do it. It was proposed to be done before elections, my lord. It just because of. But now with Lordship's directions, my lord, the process is about to be completed within 10 days. The envelopes, sealed envelopes are to be opened. That's it.
495 of each. Can't accommodate 500, my lord.
There are 2-3 colleges, my lord.
They can't accommodate 150 each, my lord. That's not possible. They have a sanctioned intake of 100.
Their own intake.
They can't take more than that. Lord, state may be directed to sanction the full load, my lord.
As pointed out by the Council for the University, my lord, the sanction strength is 8. They have to extend that limit, my lord, and that is to be done by the state government. As informed by my friend, my lord, that 3 appointments are already kept in the sealed cover.
15 days. Only because of the guideline.
Code of conduct कब खत्म हो रहा है?
Notification.
No, my lords, there are no standard prescribed for room sizes or building sizes. We all have them, my lord, as per the norms. My lord, we have in our return, my lord, we have given details, my lord, that is document 5276. My lord. We have given the infrastructure we have, that is on page number 20. We have a HOD's room, my lord, which is in size of 4.3 4.2 into 7.2 would be coming in the month of June, my lords. My lord, with teacher's appointment, taking it to the sanction strength, we'll do it within 10-15 days, my lord. Not more than that, because the process is already complete. The envelopes are to be opened. My lords. For teachers and for the other infrastructure is. My lords. My lordship. I'll just seek instruction and would come back before this on. How much time would be required? Because for infrastructure, the Bar Council also says that they say. Lordship may give me 5 minutes. I'll just.
You know, state may also seek instructions as to by when they will sanction the remaining. My lord, university will say we are doing it so far as the sanction strength is concerned. What about the strength, my lord, 50%, which is not? My lord, then it will be again deficit, my lord. My lord. My lord.
It doesn't matter, Malab, where. Yes, they have filed for the recommendations of the Human Rights Commission to be implemented by the state government, Malab. Malab, he was there. Like my lords of.
Worship, Mr. Shruti is before another bench, my lord. It may be taken up next week. Grateful.
My lord, the counsel for the petitioner is connected through VC, my lord.
Matter appears to be wrongly listed. My lord, may have the order sheet dated 22nd of November. 22nd November. Order sheet. Here is already an interim order. And usual course hearing order is also there.
Please, this comes for admission, and my lords are in fact by an order dated 15th November 2021 directed that this matter may be posted for hearing in usual course. This is a writ petition challenging a communication by the Indian Bureau of Mines seeking to revoke a mining plan.
I'll inform him, my lord. So inform him.
Your Lordship, the petitioner is challenged to regulation 701 and 704 of the MP jail regulation, alleging wherein it has been mandated that if a convict commits another offense specified in those regulation during the currency of the punishment, the remission that they have earned shall be forfeited. We have filed our reply.
May it please your lordship. My lords, on the last date of hearing, my lords were pleased to issue notices. At this juncture, my lords, I humbly submit, in a matter involving the exact same issue, my lords have stayed the impugned order. If I may submit a copy of that, my lords. I will also supply to the other side. My lords, I have supplied the copy of
What I'm very
petition also in that case. It is the exact same case, my lords. My lords, the only difference was that my lords, in that case, we came exact same party also, my lords, exact same mine also.
Not in an identical matter.
Just a different response.
Petition number 2848/21 is pending, my lord. Lord, in that almost the entire pleadings are completed. This is also between the same parties, my lord.
My lords, that is on a different issue.
This matter will be linked along with this, that WP number 2848/21.
Your lordship, in this, there is only one order, and by mistake, I filed 2 stay applications. So one stay application, my lords permit me to withdraw. My lords, order dated 15/3/21. Grateful, my lords. My lords, I oppose linking with that WP because that's on a different issue of SHRI. My lords, grateful. My lord.
Yes, the agricultural land of the husband of the petitioner was acquired for the purpose of national highway. The award was passed, was for enhancement of the compensation. I approached before the divisional commissioner cum arbitrator by improve. Yes, my lord, it is dismissed on the ground of delay, my lord. Annexure P8, page number 53, my lord.
May I just make a submission also? The remedy lies under the provision of section 34 of the Arbitration and Conciliation Act before the district court against this order which has been impugned in this petition.
My lord. In one of
amount of award has already been paid in the year 2015 also.
In one
after the lapse of 5 years, if it are
in one of the matter, my lord, WP number 13670/21 on the ground of delay only delay.
also, can I appreciate the last 2 paragraphs of the state order university, wherein that the finding has been given to that extent.
The award was passed in the year 2013 and I approached before the arbitrator in the year 2019, my lord. As per the order, there is a 5 years delay, but as per my contention, my lord, there is only 11th month delay because the award was passed in the award was granted in the year 2015, my lord. And on the 15, my lord, 3 years limitation would be applicable. And in the year 2018, my limitation was lapsed, my lord. And in the 2019 month of September, I approached before the arbitrator. Only delay of 11 months.
Yes.
Also, this is the medical matter of the medical reimbursement. That is the matter of medical reimbursement, lordship. The reimbursement amount, lordship. Actually, lordship, I am compulsorily retired additional district and session judge. My father.
Lordship, I'm praying that this matter may be taken up in next week, my lord. Last date they have seek time to file rejoinder, my lord. It hasn't come on record.
Senior is before another bench, my lord.
Lordship, that is 6/2/2020 and 12/6/2020, Lordship.
When a rejoinder has been filed, my lord, if I may be permitted to, let's seek any response, if any at all. If at all any response is required to be filed.
Yes, my lord. My lord, the case pertains to the fact that there was a scheme of the government, Mukhyamantri Yodhya Kalyan COVID-19 Yojana, my lords. In that scheme, it was mentioned that whoever has warrior has died while on duty, and compensation of rupees 50 lakh is required to be awarded, my lords. In this case, my lords, the petitioner's husband has died during COVID, and as per the procedure prescribed under the guidelines issued by the state government, a screening committee was constituted. The screening committee has given a recommendation that he is entitled for award of compensation of rupees 50 lakh rupees. My lord, the report of screening committee is at page number 35. Yes, my lords. I may just read one paragraph, my lords. स्वर्गीय श्री कृष्णदत्त पाठक सिटी मिशन मैनेजर नगर पालिका परिषद छतरपुर के दौरान मुख्य नगर पालिका अधिकारी छतरपुर द्वारा प्रस्तुत प्रस्ताव का परीक्षण किया गया, जिसमें पाया गया कि श्री कृष्णदत्त पाठक सिटी मिशन मैनेजर की ड्यूटी नगर पालिका क्षेत्र छतरपुर में वार्ड 21 से 40 तक वार्ड एवं कंटेनमेंट एरिया में सैनिटाइजेशन करवाने तथा आश्रम स्थल पर निराश्रितों को रुकवाने तथा उनकी खाने की व्यवस्था सहित कोरोना वायरस के रोकथाम के समस्त उपाय करने में लगाई गई थी। श्री पाठक उक्त ड्यूटी के दौरान कोरोना पॉजिटिव होकर इलाज के दौरान मृत्यु हो गई है। मध्य प्रदेश शासन राजस्व विभाग के निर्देश दिनांक 10/4/2000 के बिंदु क्रमांक 3 एवं 4 के अनुसार कोविड मरीज के सीधे संपर्क में आने से श्री पाठक कोरोना पॉजिटिव हुए हैं, जिनका इलाज के दौरान निधन हो गया है। अतः स्वर्गीय श्री पाठक को समिति द्वारा मुख्यमंत्री कोविड-19 योद्धा कल्याण योजना के तहत पात्र पाया गया तथा प्रस्ताव शासन की ओर से भेजने की सहमति दी गई। This was the recommendation of the screening committee, my lords. Your lordships, then there is another annexure P7, your lordships may kindly see.
Our replies there. The policy may kindly be seen, my lords. Page 24, it starts, my lord, clause 3, and if I may be permitted to read. क्लॉज 3.1, ऐसे शासकीय कर्मी जो कोविड की रोकथाम हेतु प्रत्यक्ष रूप से अपनी सेवाएं दे रहे हैं, अर्थात कोविड इलाज हेतु नामित अस्पताल, कोविड केयर सेंटर, कोविड टेस्टिंग लैब, क्वारंटीन सेंटर में या कोविड-19 की रोकथाम हेतु घर घर सर्वेक्षण, नमूना संग्रहण, जांच, कंटेनमेंट एरिया में पर्यवेक्षण, साफ सफाई आदि विभाग विभिन्न कार्यों में तैनात हैं, जिससे उनका सीधा संपर्क कोविड मरीज से होने की संभावना है पात्र होंगे। मतलब the duty assigned to the deceased husband of the petitioner was for sanitization, and my lord, the relief commissioner has given a finding that in that duty it cannot be assumed that he was coming in directly in contact with the COVID-19 positive patients. So my lord, that is the finding which they have given, and based on that they have rejected the claim.
Bylaws in containment. Yes, I'm sorry.
Containment areas. That is the finding. But we'll reconsider.
Because they have no reasons have been assigned illegally that has been rejected by the relief commissioner. That's Lordship has been 24/4/2021. Mukhyamantri.
Clause 3.1. Given and taken.
Obliged, my lords.
May please, my lord. It is a matter where in the first round, it was asked that whether this matter comes under the section 14, my lord. And this is in respect of appointment of a member of a Buck board, my lord. Now, there is a, that who would be the member of Buck board, my lord? Kindly see section 14 of Buck board act, my lord. We'll start. Pardon, my lord. Pardon. May I continue? Non-obstante clause.
14.3.
That is a non-obstante clause. Now the appointment is to be made, the constitution has to be made in the light of 14.1, madam. Can you see 14.1? 14.1, madam. 14.1.2. Now can you see, my lord, composition of board, my lord. My lord, may get it? Yes, my lord. Muslim members of the state legislature, my lord. Now, my lord, if no, now the non-obstante clause, because when there is a procedure.
Yes, my lord. My lord, may have their reply itself, my lord. Para 8 and 10, they themselves saying the order sheets have been filed saying that because there is no electoral college, therefore excising par under 14.3, they have nominated and they have not opted for election.
May I explain? Well, what happens, my lord? When there is, my lord, there is a, the law says, my lord, what law says? Law says, I say, my lord, that there, para, my lord,
Not para 10, if your lordship may kindly see. Para 8 and 10 of the return.
Eight. I'm just coming here. I'll read it. If I'm just, what I'm saying, however, subsection 3 of the section 14 specifically provides, it's a procedure where when the person, when there is a the elected members are not there, my lord. Right? We have nominated the person who was elected, who's an elected member in the parliament, in the legislative assembly. This is what the requirement. Now, the procedure is prescribed, my lord. There is a procedure which says that when there is to be a selection or the election of the person from those persons, my lord, those who are elected members, then in that eventuality there is a procedure prescribed which says that, my lord, there would be proposers if there are two candidates. There are two candidates, madam. There would be a proposer and thereafter their name have been proposed. And in that eventuality, if that has not been there, then, my lord, the state can nominate for the purposes of two. Member could not be the other person. It is the elected Muslim member only. And the person who has been appointed is the elected Muslim member. My lord, may kindly see now 14.3, which is a non-obstante clause. Why it comes in, it came in existence. Why it is there for? To rescuing that key person should be there. That is the elected member. And that too, he is the elected member. It is not the case that he is not the elected member of the the Legislative Assembly. Oh my, I'm so sorry for that. Could I get chance? Could I get chance to? I will explain it in next week, my lords. My lords. My lords. My lord. For the reasons, my lord. 40. Because, my lord, there is a procedure to appoint a legislative member who belongs to Muslim caste, and that too by way of a procedure prescribed. My lord, I will read for my lord's kind consideration. It says, notwithstanding anything contained in this section, where the state government is satisfied for reasons to be recorded in writing that it is not a reasonably practicable to constitute an electoral college. My lord, electoral college has to be constituted for the purpose of selecting the elected member, or the elected member of Muslim in the Legislative Assembly for being a board member. An electoral college for any of the categories mentioned in subsection 1, 2, 3. 1, 2, 3. Third is the category for the of clause B of section 1. The state board may nominate such person as the members of the board as it deems fit. My respect for submission is that, my lord. If my lord, if I am not in a position to. May I submit? For appointing the person, Muslim members of the state legislature in the composition of board, there is a requirement of electoral college, my lord. Now, for that electoral college, my lord, there is a requirement that the proposers are to be there, my lord. When the proposers are there, then only the person who is already been elected as a legislative member to be a board member, he has to contest that election within that. And in that eventuality, if the electoral college cannot be constituted, that in that eventuality, for selecting number 2, the Muslim members of the state legislature, the state government can nominate, and that is very much there in my in the order, my lord. That is R1. R1, I will read it, my lord. Then I will try to satisfy, my lord. R1 is, my lord, at page number 10, my lord. At page number 10. May I read it, my lord? वर्तमान स्थिति की दृष्टिगत इस श्रेणी में केवल 2 मुस्लिम विधायक हैं. Now the person, those who are proposed, they have to be also the member of legislative assembly, my lord. वर्तमान स्थिति की दृष्टिगत इस श्रेणी में केवल 2 मुस्लिम विधायक हैं और दोनों ही अभ्यर्थी हैं, परंतु प्रावधान अनुसार इनके प्रस्तावक नहीं है. There is no proposer, my lord. So the electoral college cannot be created, my lord. And when the electoral college cannot be created, then they cannot be appointed by way of this, my lord. Then the state government can nominate them. They ought to be the elected legislative members. But selecting them, for selection of them to be the member of Bug Board, there is a requirement of this proposal, my lord. There is no proposal. So therefore, my lord, the state government has nominated the name of respondent number 6. Please, under, my lord, this has been used as in the exception covered and the non-absentee clause. Appointment can be done in only. My lord, it is the rules, my lord, which, my lord, I have read it. वर्तमान अनुसार निर्वाचक मंडल स्थापित नहीं किया जाता तथा चुनाव हेतु निर्धारित प्रवचन के लिए नाम सो yes, my lord. I do agree, my lord, but my lord, what I am saying is, or I'm not in a position. I'm just apologize, but I could not explain much. If my lord will keep it for next week, I will try to gather it and I will explain it. Because, well, there are rules also, my lord, which are not. I cannot lay my hands on them. Yes, my lord. Because, yes, my lord, for electoral college, my lord, there is no constitution of electoral college, my lord.
The affected party. Simply adopted the reply filed by the state government.
May I submit, my lord? No, no, may I pray, my lord? My lord. I'm so obliged, my lord. I'll prepare when I'm so.
Lordship, next week may kindly be, Lordship, 1 week may kindly be given to submit my rejoinder and reply of their application, Lordship. But they have given me just now this return, Lordship. And return is also incomplete. The 4 pages are not available in the return, Lordship. So they have incomplete return they have filed.
No, in fact.
And no advance copy has been given to me, Lordship, till date.
I've served entire copy. In fact, it will served on WhatsApp also. And if there's a problem to contest matter to do the matter next week, I'll supply him the copy again. Mother. That's not an issue. But there's an application for vacating stay also, mothers.
No.
Because it's yes, not tomorrow. Mothers. No, I'll do that.
2 weeks, about 2 days, Lordship, day after tomorrow, Kadi. Lordship, because the petitioner is out of Jabalpur, Lordship. I will call him, Lordship. 2 days time. No, Lordship, I will seek some clarifications from him, Lordship. Person रख दीजिए, Lordship, please. Obliged. Obliged. Milord, you have to inform Milord how much time they are going to take, Milord.
2 months, my lord, we'll do the appointment up to the sanction strength, my lord, for which we have issued advertisement. So for remaining within 7 days, my lord, state sanctioning the further post will 2 months. Sir, sanction strength जो है
Milord, I cannot give an undertaking right now, Milord, but I'll inform them, Milord, to issue a show cause notice why they are not fulfilling the condition, Milord. 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 Then action will be taken. Then action will be taken. Milord, not granting them further affiliation of approval. Yes, Milord. 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 Milord.
for the respondent number
You
2
know.
and 3, my lord. You know.
Bar Council. The Bar Council of India rules requiring the
I have a caveat. Can only give appointments. The state may also help us.
We are not
No, my lord, the state may also, my lord, no, for my lord, what?
Bar Council. No.
Knowledge is given by and is run. And this
Legal, yes.
transferred or any other.
What I submit, we'll do it within 2 months, my lord. Only that part be there. We withdraw all the other arguments with state, we'll fight with state, my lord. Sir, within, sir, wo Purana order if I pray for, my lords. We'll do it within 2 months, my lord. This is what we are praying. My lord. What, 2 months for appointments, my lord, and could that be, my lord, we are, my lord, what I say, my lord, we have, I may be given that liberty, my lord, I withdraw the other argument. So, no, my lord, no, no, my lord, we will do it within 2 months. Then, if lordship.